All right, before we go back to court, folks, I want to bring in our guest for this hour. Joining us to discuss, criminal defense attorney, former prosecutor David Bruno. David, great to see you as always, my friend. Thank you so much for being with me on the program tonight. And first and foremost, I want to get your general thoughts about the case. My general feeling is that it's one of those cases where, if not him, then who? I don't think the defense, and they don't have to do this, but I think there may be a need for it in this case to show that somebody else might have done this, because you do have some evidence. You got the missing saw, you got the body parts found across the street from where he used to work. You do have the domestic violence. I mean, all those things point to this defendant. And again, not too many other viable options.
Yeah, all good points, Mike. I mean, if not him, then who is not reasonable, beyond a reasonable doubt. The prosecutors got an uphill battle. They got a circumstantial case, but what's lacking is the forensics. You know, the timeliness of that report is going to be real problematic for the defendant. But honestly, where's the forensics? Where's the things that tie it together? There's also that huge gap in between the crime and the charges. And the statements from the daughter, helpful, but again, you know, it's a banter sort of back and forth. I don't know if that's an actual admission. So I think the prosecutor is doing its best with what it has. However, this is what the proof beyond a reasonable doubt standard is there for. It needs to get over the hump. And let's see if they could do it circumstantially with the evidence to come.
Now, we don't have an admission, David, but what we do have, and I want to get your thoughts on how probative it is, we have a guy who was cooperative throughout the case. Over the course of years, he gave them samples, hair samples, buccal swabs, interviews. But the minute they came to arrest him, he's hiding out. And he didn't want to come out and get arrested. They're claiming that shows consciousness of guilt. Not sure what it shows, but that's one of the things that put me and keep pushing me towards guilt. What do you think about the fact that he was hiding out when they came to get him 20 years later?
Yeah, that is key, you know, for prosecutors when they have that sort of behavior, because they could make the argument of consciousness of guilt, and especially on a circumstantial case when they're trying to pile on inferences. That is yet just another inference that you ask the jury to come and find, which is that what other explanation would there be for this individual to hide out like that? And I wonder, too, does that force the defendant to the stand? I mean, ideally speaking, the defense does not want to put him on. They want to challenge the burden of proof. And it's a very different case, and we've had this conversation before, between making the argument that the prosecutor hasn't proven that case beyond a reasonable doubt versus when your client testifies and the credibility is now being equally assessed as any other witness for that jury. And oftentimes the juries could focus on that credibility when the alternative would be the proof beyond a reasonable doubt argument.
Yeah, it's a tough one when the state's case not super strong, right? Because then kind of switching things there, and it could work in your favor, could not. All right, stand by first. Before we go back